Okay, here we go. This might piss some people off, but honestly, I'm beyond caring at this point. For those who don't know me, my name is Daniel Gaines. I was married to a woman named Juliet, and we had a child together. Well, here we are almost 17 years later, and for not the first time, but the second time, my ex-wife has been brought up on criminal charges. Now, if y'all want a little more background information about her, just a quick Google search of Juliet Parker will reveal all you need to know. You'll see the headlines about the Washington mother, blah, blah, blah. This video is not at all going to speak to the facts of that case or even questions of guilt or not. I have no information about that case. I am actively being blocked from even finding out anything about my daughter's part of the case. I wouldn't discuss it even if I had the information, nor will I even entertain any questions that I might get about it. So please just refrain. Now, onto the civil side. Due to the arrests and everything else of Juliet and my daughter, CPS has gotten involved. Now, there's been a custody battle in Washington. This will be the third or fourth time. It's been in restraining order attempt in Oklahoma. I believe in Texas, there's been a court hearing for custody in California. And this has been ongoing since 2004. Now, this time CPS is involved and they're doing their thing, right? Well, on this stuff, it's kind of interesting. I'm going to try to keep most of these videos around 20-30 minutes in length. This one might be a bit longer because I'm going to play an audio recording that's going to be 10 minutes long, and then we'll get into it. Now, my allegations have been, from the start, parental alienation. That I've never had a choice in being a part of my daughter's life. My ex-wife has fled jurisdiction multiple times to avoid me having any kind of relationship or being able to establish any contact with my child. And court documents will verify that that's always been my claims. Now, get to now. They get arrested in February, get going and stuff. Got to deal with CPS, right? There's supposed to be a meeting with CPS to discuss what's going on with my child. I was supposed to be a part of it. Juliet was supposed to be a part of it. My daughter's probation officer. I think the case investigator, supervisor was supposed to be a part of it. Maybe the case investigator, Carolyn Myers or whatever the hell her name is. Now, keep in mind, this was after they've already spoken to my daughter about things. This was before any documents were filed with the courts, but after they've already spoken to my child. Now, here on this video, I'm going to show you. Let's see if we can get it to where I can see it. 10 minutes long, right? Or the audio, not video. This audio is 10 minutes long. We're just going to set it down and push play. As you can see, it's playing.
say your name and I did.
What number did you have?
The one that I was texted yesterday.
712-775-7270. Okay, so maybe I hung up on you by accident. So I'll hang up and I'll get you on the conference line again.
Do you want me to call that number back?
I was thinking anybody else other than Danny call it. So why don't we just, when I put you on speaker, we'll go ahead.
Oh, okay.
Okay. So which one? I'll have to work out. We basically had to in my time. You know, drinking that several years ago, we we know that we're not violating any laws, and Caroline will get in touch with you to set up a separate meeting.
Wow. So again, she's able to just constantly run with my kid. Now that she gets my kid in some serious criminal trouble, I can't even be involved.
Not in this particular meeting, but we can.
That's all right. I'll be up there Monday and we'll see what the courts say Monday.
Be involved, but because there might be no contact order between you and Juliet, we can't actually participate together.
There is no contact order between me and Juliet. I can assure you of that.
I don't know what to tell you. We're going to research it and then have a separate meeting.
We'll see what the courts say Monday. Have a nice day.
Now, did you notice whenever I said there is no contact order in place, I was told I don't know what to tell you? It's kind of a fucked up thing for CPS investigator to say, isn't it? Especially whenever there were no documents to prove Miss Parker's claim, Juliet's claim, that there was a no contact order, or anything of that sort, or anything of the sorts. Kind of odd, kind of asinine, and kind of even ridiculous that it would be entertained without any kind of documents, especially whenever the last custody hearing and the last time any attempt at a restraining order or no contact order between me and my ex-wife was done in 2015. Facts of the matter are, the judge kicked it instantly. It can be looked into in Mason County, Washington, Parker v. Gaines, in the civil courts. It's all public information. Anybody can go check it out. Check it out. Look it up. The restraining order was kicked. Why? Well, she made the claim that she was pushed or thrown. I don't remember which specific word she used this time, but something about pushed or thrown down the stairs when she was 7.5 months pregnant, that I was on meth, and that I was a severe alcoholic with anger issues and such like that. Teeth may not be straight. Wisdom teeth kind of fuck that, but as you can see, I've got my teeth. Clearly not a meth head. As you can see, a little bit of chub on the cheeks. Clearly not a meth head. Now, she made these claims after literally 8 years of no contact. See, the last time I seen my daughter was the day of her 4th birthday. This July, she'll be 17. Now, the day of her 4th birthday, she'll be 17. Mind you, I mean, she was born in 03. Last time I seen her was the day of her 4th birthday in 2007. In 2015, my ex-wife knows for sure that I'm on meth and I'm an alcoholic. Ain't seen me, ain't heard from me, ain't given me an address, ain't given me the opportunity to talk to my child, don't know jack about my life or anything else, but you know for certain I'm on meth. Funny thing is, the woman I'm with now, I was already with for 5 years at that point. Something doesn't add up about things. But that's that. Oh, and I do think it's relevant to note that if you were to pull the transcripts from the Mason County restraining order hearing, I believe it is, you will hear Juliet literally, while under oath, change her story 3 times in less than a 5-minute span to the judge. Under oath, nary a word was said by this judge. His name will be released in the later video. Don't worry, all these some bitches are going to be named publicly. I don't care. I live in Missouri, not the state of Washington. My laws allow me to record audio record conversations. I can release them. It's my case involving my child. I can release that information if I want. And I don't care if I can't release your names because you have an issue with me doing so. Because what are you going to do? Keep my kid from me? You've already done it for almost 14 years. She'll be 18 soon. I'd rather her know the truth than y'all's bullshit anyway. So if this way ensures that she eventually can at least learn the truth, so be it then. She'll be able to make her own decisions at that point in time. Now, keep in mind I stated that Juliet was arrested in February. Valentine's Day, in fact. Her and my daughter both. They, fast forward. We're into March, early March at that. CPS is involved. Right? Okay? Now, check some of this shit out, people. I want you to see that it's not just being made up. That it's legit bullshit what these motherfuckers are doing. Washington State is alleged to be one of the most biased states in the country when it comes to fathers' rights. You're going to see why. It's not just alleged, to be honest with you, but you're going to learn. Oh yeah, you're going to learn. Now, I don't know how to flip my camera around. I'm not tech savvy, so we're going to do this old school and weirdly. Like, pardon me, forgive me. But anybody can pause it and screenshot it. Now, as y'all see on this document, it's got mother's name, father's name, mother's address, father's address. Y'all see how it says father's address unknown? Okay. Can y'all explain to me how I contacted CPS, told them who I was, told them all my information, phone number, address, where I lived, everything, and then they filed this, and I contacted them in February, mind you. I can prove that with phone records, and we'll be doing so in court and everything else, probably, and on one of these videos for everybody else, but that's at a later time because there's much more information to do with CPS. Just a little bit in this video, but it's more so about some bullshit for this video. But anyway, I digress. They listed my address as unknown. They were given my address before they listed it as unknown. And I wasn't given these documents until the day of or a couple of days before the hearing, day of the hearing, somewhere right around the hearing, fairly close to the first hearing, right? When I asked about why, these assholes at CPS told me they sent certified mail for me to my ex-wife's address in the state of Washington. Y'all know she's my ex-wife. Y'all know this shit's contested because you've already forced me off the phone call and such based off of a no contact order and shit like that. And then you're going to send a certified letter from me to her address about court information. But there's no bias. Okay, check this out. And this isn't even, we ain't even getting warmed up yet. People are going to think this is some damning information. Nah, sweetheart, we ain't even getting warmed up, I assure you. Now, this one I have to be careful with because I didn't white out. I dropped my phone. I didn't white out every bit of the information because there's only the one paragraph I want people to see for now. Don't worry, the rest of the redactions will be coming. My daughter's minor brother's name is in here, and that will not be released, nor will my child's if I can prevent it. They're minors, it's protected. Now, this was on March 6th, and it's from CPS. It states, I'll read it and then I'll show it. It says, on 2/20/20, February 20th, 2020, the child, meaning my daughter, was asked about her relationship with her father. She stated she did not want to stay with him. Child reported that her father is a drug addict, an alcoholic, and that he shoved her mother down the stairs when she was pregnant. Child reported she did not want phone calls with her father and that he was never there for her in her life. That's what my daughter told CPS in March. Make sure it's all on there. Give folks plenty of time to be able to screenshot it, to read it the damn self. That way you can see it's not bullshit. And look. I hope y'all got that. Oh no! Well, that sucks. Yes, that just happened. My shit just blew everywhere. Ain't that a bitch? But it's all good. Most of it I stopped. There's only a couple pieces that blew off. So let's go collect those while I do this. But anyway, in the document I showed you, it was part of the CPS document. And I'll take better pictures and stuff like that at a later date and time to get more information out there. So that's what my daughter said to CPS in February. Now, keep in mind, CPS is aware of the fact that the last contact my daughter had with me was the day of her 4th birthday. In February 20th to be exact, she told CPS that I was a drug addict, an alcoholic, abusive, and never wanted anything to do with her. How is it that a kid that hasn't seen somebody in almost 13 years, knows anything that like that is true? How is it a child can attest to those things as factual when it's impossible for her to know from personal experiences? That's where the parental alienation and malicious mother syndrome comes in. Look up the definition of them. You'd be doing yourself a bit of a favor in that regard if you're interested to learn things. But anyway, it's basically turning the child against one parent in favor of the other, in a nutshell. But it's done with intent, and it's done deliberately, as is clearly the case, which I've always maintained. Now, in this document, specifically right here, it says, states child told her that when her mother was pregnant with her, there was a lot of domestic violence between mother and alleged bio father Daniel Gaines, who allegedly pushed mother down the stairs when she was pregnant. Child says mother filed a restraining order against father. Now, in this one, which is recent, this one I actually just received Tuesday, which was the day of the next hearing. I didn't get the documents from CPS until the day of the hearing. Yeah, it's like that, folks. I don't get documents, but they all do. Anyway, I get the documents. I look at them, it says something different, but it says that that's what the mother told the child. Now, I may not be the smartest man in the world, but based off the legal definition of parental alienation and malicious mother syndrome, all criteria is met. Again, I may not be a very smart individual. I may not be the most educated man in the world. I understand to these folk, I'm just some redneck hillbilly from the state of Missouri. But why is it that these CPS investigators, these CPS attorneys, the GAL, the child's attorney, both my ex-wife's attorneys, and the judge have all failed to notice this? Me, without an attorney, because the attorney that the courts appointed for me was negligent in her, or derelict in her duty as an attorney. She was indifferent about the case, wasn't working in my interest, and that Lucanville is her name. And I can prove all my claims. I've got emails, phone records to verify and everything else. So I'm not worried about them getting pissed off or them getting getting their panties in a bunch or anything like any of those sayings or whatever. I don't care. I don't care. I can prove my claims. Come at me. But anyway, it's amazing that I'm not an attorney, but yet I'm the one who's got to point all this stuff out to all these people. All these attorneys and investigators and everything else are missing this. Hold on a second. Now, enough about that. Let's get back to that audio recording, shall we? In the recording, you heard my daughter say, in the beginning, the young little, sounded like crying voice, the younger child sounded like. Come to find out that, in fact, was my daughter. Right? You heard her state, do you have his number? Can we call him? And then she states, I want to meet him. Now, in the documents where CPS is stating that that Faith told them I'm a drug addict and all this, the CPS is telling the courts that my daughter wants to have, or CPS put that in the court documents and then turned around and put in the court documents after this audio took place, after the date of this audio recording, turned around and told the courts that my daughter wanted nothing to do with me. But yet I had audio proof they did. Okay. So the courts say the exact opposite of what my child says to them, and I have it on audio, that CPS was told one thing by my child, and then CPS turned around and told the courts another thing. And it was the CPS investigator and her supervisor. Her name will be released in the next video. But Carolyn, the investigator, she should have known better than what she did, but she didn't care because I'm the father, and well, they don't give a shit because she's the one that said, basically was like, oh well, in the end of the audio recording. Now, in the audio recording, this is where things get fun. You hear my ex-wife clearly state that the last time we were in court several years ago, the order that was granted, I was allowed no communication, no contact with my child or her. Actually, she stated with me or our child, right? The order that was entered in 2015, there was a no contact order issued for my daughter. Okay. Juliet, I'll get to that in a second, but there was never one issued against for Juliet. So instantly, her first reaction is to lie to CPS to prevent me from getting the information for my child, about my child. Block access, prevent from getting information. Malicious mother syndrome. And she lied to do it because she knew there was there wasn't a no contact order in place. She just said so in the hopes that she could prevent me from having the information. And it worked. I had to wait 4 additional days. And the emails I'll be releasing will verify that. Okay? So, they tell me they're going to have to let me go. I can't be on the call. You hear them tell her that when she says she can't find the document, it must be in a different set of documents or something like that, that says there's a no contact order between me and her, meaning my ex-wife, Juliet Parker. The CPS workers said that, the CPS workers straight said, we'll have to check into that. We'll look into it. We need to verify. Pardon me again. Whenever I said that there wasn't any no contact order in place, they basically told me, oh well, you have to prove that there isn't. And their reason for putting me off the call sounds sweet and beautiful and everything like that, right? We don't want to violate any laws. Well, they violated my rights while doing this. That's what they're neglecting to mention because they're trying to lie and say that it never happened. However, is what I would like to point out. They did, in fact, already violate the fucking law. How so, you say? Well, their concern was they didn't want to violate a no contact order if there was one in place between me and Juliet Parker, my ex-wife. But what they failed to realize is they already violated a no contact order, the one that actually was a legal court order, the only one pertaining to me and my child. They gave me a time to call in, 2 p.m. I believe it was. I'd have to look at emails to confirm, but I'm pretty sure it was 2 p.m. Not my fault I'm punctual. I called it too. My daughter was in the room, and those were the comments she was making. I introduced myself as you heard me say in the audio. I said my name whenever I came in the call, like it said to do. So, they violated the real court order, and then used the justification they didn't want to violate the lied about and make-believe court order. And then because I had the audacity to question it, which these emails I'll be releasing soon enough will show, that I questioned it, and because I did, they submitted a document that I'll be showing later to the courts where the CPS investigators, Carolyn, and her supervisor, and their attorney, Miles Russell, all think that I should have to go undergo mental health evals. I should have to do random drug analysis. They're trying to have the courts tell me I'm not allowed to have alcohol. I don't drink anyway, so that's really not a big deal. Haven't drank in almost a decade. So I don't give a shit about that, but it's more the point. But trying to say I have all these hoops to jump through. Now, keep in mind, CPS, the same fuckers that are trying to get me to have to do all this shit, are the very ones who supplied the court with the conclusive evidence and proof beyond any dispute of the parental alienation and malicious mother syndrome. But yet they're still vilifying me. Case in point. Make a quick example. I sent an email. My attorney was fired, but I had to wait for the court hearing to actually dismiss her from the case. But I emailed the people and told them, I don't have an attorney anymore. Any documents, get to me.